All rise, veuillez vous lever. Please be seated. Veuillez vous asseoir.
L'audience est reprise. Comme prévu, la parole est à la défense pour les plaidoiries finales. Maître Taylor.
Thank you very much. Mr. President, Your Honours, in my opening statement in July last year, I started by painting a portrait of Mr. Hassan, who he was before, during, and after the events. But today, rather than using my words, I'll speak with the voices of prosecution witnesses to show why the person behind me, Hassan Abdulaziz, does not belong in this courtroom. P654, a local Songhai notable, described Hassan as a petit sardine, not an Ansar Dine leader. He said that Hassan was timid, peace-loving and friendly. A repairman who was working to restore services in Timbuktu told P654, "It's a good thing you've got a guy like that to facilitate things for us." P150, a prosecution witness, referred to Mr. Hassan as an honest, straightforward man who was beloved by the people. He agreed that Hassan was someone who helped people and who wanted to protect his community. P65, another prosecution witness, described Hassan as a non-extremist, someone who had been pushed by his tribe to join Ansar Dine to protect the local community. And P65 confirmed that that is what Hassan did. He protected the local community, and people talked about how positive Hassan had been to them. P608, a prosecution witness, a local Songhai woman, depicted Hassan as a little fish, someone who was very nice to the local population. P1086, a prosecution witness who was a former MNLA soldier, testified that he heard said that Hassan was amongst the people who remained in Timbuktu to help people, to make people's lives easier in Timbuktu. And he heard said that Hassan had in fact helped a lot of people. You have heard a multitude of concrete examples of Mr. Hassan helping the local population, but what you have not heard is any evidence from the alleged victims of the charged events that Mr. Hassan himself harmed them, that he was responsible for causing harm to them, or that his actions made the situation worse. In the words of P608, "I didn't deem him to be responsible for the acts that brought him here. And more, what is more, I did not identify or hear people speak about something that he did personally." And that is the missing link. The link between Mr. Hassan's knowledge, intent, and actions, and the commission of the charged incidents which form the exclusive basis for your judgment. Today, I will show that for each month of the charged time period, the prosecution has failed to demonstrate, beyond reasonable doubt, that there's a culpable link between Mr. Hassan and the charged incidents. prosecution case on this point is like a Trojan horse filled with errors that come tumbling out as soon as you look at them more closely. Metro Pardon will address you concerning the absence of any reliable evidential foundation to make such a link, and the broader absence of any nexus to an armed conflict or widespread or systematic attack perpetrated pursuant to an organizational policy. My colleague Maître Beaulieu will address you on the point that the prosecution has failed to demonstrate that Mr. Alassane knew of the charged incidents pertaining to sexual and gender-based violence, or that he played any measurable role in bringing them about. My colleague Maître Youssef will also explain the absence of any culpable link between Mr. Alassane's alleged role in the Islamic police and the judgments and punishments issued by the Islamic Tribunal. Finally, Dr. Gary will explain that through the operation of positive defences, the Chamber cannot enter a conviction in relation to conduct that was mandated by superior orders or carried out while Alassane was under duress or a mistake of fact or law. Your Honours, Article 25.3 of the statute was not designed to penalise small fish who carry out day-to-day routine acts for groups we don't like. Nor should its language be contorted by judicial fiat to achieve such an outcome. It would indeed be a Pyrrhic victory if the court were to collapse under the weight of harmless small fry. It is therefore necessary to give full effect to statutory provisions concerning mens rea and the required actus reus. And I will explain today how the prosecution's case fails to do so. At footnote 15 of the prosecution's response, the prosecution concede that it is necessary to demonstrate a link between Mr. Alassane's contribution to the common purpose and the commission of the charged crimes. And they refer to the Taganda appeals judgment, where the appeals chamber confirmed that the principle of causation requires a causal link between the conduct of the accused and the crime for which he or she is responsible. And that's paragraph 104.1 of the judgment. This causal link means that the contribution must play a measurable, a quantifiable role in bringing about the crime in question. And since the Rome Statute does not penalise the butterfly effect, the prosecution must also prove a sufficient degree of blameworthy contribution. And to be blameworthy, a contribution must be accompanied by knowledge and intent. Knowledge is defined by the statute as awareness that a circumstance exists or a consequence will occur in the ordinary course of events. The emphasis is on will, that its occurrence is virtually certain. Virtually certain means close to 100% chance of the event happening. Not a risk, not a possibility, but a certainty. And awareness must pertain to the specific incidents that have been charged. Article 30, coupled with either Article 25.3c or D, requires a bare minimum that the prosecution must prove that Alassane knew that his actions would have a measurable impact that would help bring about the occurrence of the charged incidents. And as I will show, they have failed to do so. I will start with 7th of May, which is the commencement of the charged time period for this case. At this point in time, Alassane is married. His wife is pregnant. He has a very young son, and his pharmacy in Zoho had shut down because he couldn't get medications to sell. He had come to Timbuktu to try to obtain them, but had been unsuccessful. There had been a drought early in the year, and times were very hard, particularly for the Tuareg community. Hassan was not part of Ansar Dine when it arrived in Timbuktu, and he played no role in the April meetings where Ansar Dine met with local notables to discuss their intended program. And at this juncture, Ansar Dine had already decided to apply Sharia following the Malikite approach and to establish a tribunal, a Hezbollah, and an Islamic police. All of these matters were a fait accompli before Hassan started working with the police. The die had already been cast. The Chamber has heard evidence that when Hassan joined the police, he did so as an interpreter and clerk. You have also heard evidence that at the beginning of the events, the local population were afraid that the different ethnicities would turn on each other. As written by Hobbes, without a central form of governance, life is nasty, brutish, and short. It's the law of the jungle. For this reason, governing and policing play a necessary and important role in protecting and preserving life. And this is what the Islamic police did, and their actions were welcomed by the local population. The prosecution has failed to establish that the actions that Mr. Hassan took in such a capacity at the police had a blameworthy effect on the charged incidents in the case. Instead, they've used a smoke and mirrors approach, placing significant emphasis on irrelevant or unproven claims, and even those which are patently untrue. A primary example includes their claim at paragraph 79 of their trial brief, that there was a number attributed to Mr. Hassan on the facade of the BMS, and in their words, from April onwards. And to make this claim, they cite a photo. It's MLI OTP 0012-1914. But the prosecution itself has dated this photo as 31st October 2012. So clearly, this photo does not show that the number was there in April or even May. The prosecution has then tried to use call data records, CDRs, to plug the hole in this gap. But their attempt to do so is like forcing a square-shaped peg through a star-shaped hole. It just doesn't fit the reality. Let's look at these claims in light of the CDRs. Their brief states that there were calls from Hassan to Adam from 30th April through to 25th of June. Now, we do not accept that Hassan was the exclusive user of this phone or this number, but even if attribution was assumed, the claim is completely hollow. On 30th of April, the number attributed to Mr. Hassan was in contact with a range of different individuals, including members of the MNLA and even former members of the Malian army. Notably, there are no contacts with the number attributed to Talha on or before this date, which puts to rest the dubious claims that Hassan, as opposed to his brother, worked for security in April. Now, after these contacts on the 30th of April, there are then no calls in May. The number's not used. So clearly, the number's not on the police sign at this time. Yesterday, the prosecution relied on an October interview in which Mr. Hassan allegedly referred to the early days of the work of the police. Now, yesterday, the prosecution itself conceded that the police was not set up until the very end of April at the earliest. Now, the plain meaning of the phrase first or early days is the first phase of something, that the person is referring to the first phase of the police. So this interview does not prove that Hassan worked for the group or for the police in April. The prosecution's claim, based on P150, that Al-Hassan allegedly played a role in dispersing a demonstration also does not provide a safe foundation to make any conclusions concerning the charges. Crucially, there's no reliable evidence concerning the date and the context of this demonstration. P654 testified that a protest or demonstration occurred a few weeks after the coup d'etat, but this demonstration was directed against the military junta in Bamako, and there were signs saying Senegal dégagé. P65 testified that when he first arrived in Timbuktu, he saw a protest march, and in this march he was told that people were requesting Ansar Dine to stay because they preferred the Ansar Dine to MNLA. Now, whether it's the same demonstration or not, there is no reliable proof that Mr. Al-Hassan participated or attended such a demonstration, or that he did so in his capacity as a member of the Islamic police. There's also no established link between taking steps to protect locals, to avoid violence, and the commission of the charged crimes. Yesterday, the prosecution again tried to convince you that a photo of a document establishes that Mr. Al-Hassan was working at the Islamic police on 7th of May. Now, here is why this argument is completely flawed. First, the document itself is undated. It's a complaint filed by a local against other locals who threw rocks at his pregnant wife. There's nothing in the contents of this undated document to tie it to May. Second, the prosecution's attempt to rely on a notebook does not show that this complaint was registered on or before 7th of May. It actually shows that the complaint was more likely registered later in the year. In the notebook, there is one page dated 7th of May, which lists members of the tribunal. And on the next page, there's an index of all the judgments that are included in the notebook. But this index contains cases that were heard up until November, not just 7th of May. And it's possible to see from this notebook that the case concerning the pregnant woman was heard by the tribunal between the months of September and November. And you can see this by going to page 0001, 7398, where you have a judgment dated 21st of September 2012. On the next page, 7399, we have the notes concerning the deceased pregnant woman. And then on the next page, that's 7401, we have a judgment dated 9 November 2012. Mr. President, Your Honours, the link is missing. There is no link between this case, this document, and what was heard later in the year, and the date of 7th of May. The prosecution made an arbitrary connection between one item and another without any foundation to do so. And this is emblematic of their approach to evidence and their approach to the charges. The prosecution's next attempt to place Mr. Al-Hassan at the police in May is based on evidence from P114 concerning an alleged encounter with Al-Hassan that supposedly took place on 19 May 2012. But once again, the link is missing. The attempt fails at the first hurdle because when P114 testified under oath, he explicitly said that he did not remember the date of this alleged meeting. Prosecution has then claimed that this meeting is tied to a judgment dated 21st of May. But again, the link is missing. In his evidence, P114 describes seeing Tuaregs speaking Tamashek at the BMS. The judgment of 21st of May relates to Ould Mohammed Lamine, Khaled Ould Imedat, Zaid El Abedin, Boubacar Ould Amid, and Issa Ould El Khadi. These are Arab names, and Arabs and Tuaregs are not the same. This judgment does not have any proven connection to P114's account. P11's account is also fundamentally lacking credibility. When he testified, P114 was unable to identify Al-Hassan. He was even unsure of his ethnicity. When he was first interviewed by the prosecution, he even failed to mention that he met Al-Hassan. When asked on the stand to explain why he had failed to mention this interaction, he claimed that it was because he didn't know the name of the person he had met, and it had slipped his mind because it was a trivial encounter. P114 only remembered this name he didn't know after he looked up information about the case on the internet, after Al-Hassan's arrest. And after this exposure to the prosecution's allegations against Al-Hassan, P114 also changed his evidence to pin the title of police commissioner on Al-Hassan, even though he had previously told the prosecution that it was Adam. There's more to this tale. Towards the end of 2012, P114 had described an Algerian commissioner called Hassan, who had only just replaced Adam. When asked in court to explain why he had described Hassan as Algerian, P114 testified that at that time he had not yet met Hassan. So this means that 7 months after this alleged encounter at the BMS, P114 had still not met Al-Hassan, the defendant in this case. And ultimately, when he testified, P114 conceded that it was indeed possible that the person he had met at the BMS was not the defendant Al-Hassan. And that, Your Honours, is the only reasonable conclusion you can reach based on these twists and turns, that P114 did not meet Al-Hassan at the BMS. Mr. President, Your Honours, you can use P114's evidence to agree with the defence that pre-trial publicity has contaminated the reliability of evidence concerning Mr. Al-Hassan's role and position, but you cannot rely on his unreliable account for the truth of its contents. I'm turning now to the Mosquito Net case. Now, this case, dated towards the end of May, concerns disciplinary measures taken against a member of the group, seemingly a security guard, that stole mosquito nets from the hospital. You heard evidence that a member of the Islamic Tribunal was present when this case was investigated. So Mr. Al-Hassan's alleged conduct took place under superior supervision. The related judgment also gave the doctor at the hospital the power to forgive the offender, and there is no proof, no indication that the thief actually received corporal punishment. Indeed, to reach such a conclusion, you would need to make a positive finding that the local doctor approved it. And there is, Your Honours, no evidence to that effect. And if there's no proof of punishment, there's no proof of any crime. The report does not demonstrate a culpable link between Mr. Al-Hassan and the commission of charged crimes. It does, however, show Ansar Deen working hand in hand with locals to ensure the health of the local population and the proper functioning of key institutions like the hospital. I'm turning now to June. And in June, and for the entire period when Adam was the Emir, the evidence shows that Al-Hassan acted as an interpreter and administrative clerk. Each evidential item or incident relied upon the prosecution concerning this month either fails to establish the contrary or fails to demonstrate that Mr. Al-Hassan made a culpable contribution to the charged incidents. And I'll start with a video that was filmed around 11th of June at the police station. This video is a wholly unreliable foundation for factual findings. It was taken by someone who never testified, so we have no evidence concerning the circumstances in which it was filmed, and there's no evidence concerning the identity of the persons in the video. The transcript of the video is blank, so we don't even know what is being said or in which language. By introducing this decontextualized video, the prosecution are asking you to speculate about what is being said and why it's being said. In the absence of a transcript, in the absence of any evidence concerning what was happening, you cannot conclude that this video shows Hassan settling a dispute. We simply don't know. A conviction cannot be based on a guess or a mere hunch. It is possible to see from the video that the two individuals are not handcuffed. It's been filmed from another room, so the door's open. The person alleged to be Hassan is not armed. This is not an arrest. It is not a detention, and there's no apparent link to charged crimes. At its highest, this is a video of someone alleged to be Hassan and two unidentified persons who are engaged in a consensual conversation. It shows that locals chose to bring issues to the Islamic police, showing that the local population considered the presence of the police to be a positive contribution to their security and to their welfare. I will turn now to the debt document dated 19th of June 2012. This document also is not what the prosecution claims it to be. As explained in our brief, the prosecution's description does not match reality. Stamp is not signed, stamp is upside down, leading to the more reasonable inference that it bled through from another document. The judgment concerning the debtor also refers to the creditors coming forward to the tribunal. That's MLI OTP 0078-0197. This wording, that they came forward to the tribunal, along with the evidence of a key prosecution witness, buttresses the reasonable conclusion that the debtor brought this matter himself to the tribunal. The fact that this matter was brought to the tribunal also shows that the police did not have the power to resolve disputes on such matters. At its highest, this debt document only indicates that two individuals witnessed a contractual agreement to repay a debt. And after the debtor failed to pay, the creditor toddled off to the tribunal. The tribunal then approved a repayment plan between the complainant and the debtor. And you can see that repayment plan in MLI OTP 0078-0476. Mr. President, Your Honours, this debt document does not prove any culpable link between Mr. Hassan and the crime set out in the Rome Statute. At its highest, it does, however, show the system of Islamic law being used to resolve disputes in a manner that avoided violence, and in a manner that had been used before, during, and after 2012. I'm turning now to the events of 20th of June, which concerns the flogging of two individuals at Place Saint-Coré. The prosecution has not produced any evidence that Mr. Hassan played a role in the circumstances that led to this event or its execution. There is simply no culpable link between him and the charged event. Now, the confirmed charges have asserted that he played a role in securing the event. But this assertion is not supported by evidence, nor does it satisfy the requirements of Article 25, 3D. The prosecution has relied on 3 videos to support this allegation, but none of them show Al-Hassan playing a security role or making a culpable contribution. The first video is MLI OTP 0018 0285. The person alleged to be Al-Hassan appears in a blink and you could miss it cameo. The video is 15 seconds long. At the 5-second mark, the person who alleged to be Al-Hassan can be seen for less than a second. He's not walking in the direction of the person who is flogged. He's not facing the local population. He does not have a weapon or any means for ensuring security. His actions are non sequitur. There's no link between them and the actions of the persons committing the flogging. The second video, which ends in 0252, is 18 seconds long. Locals can be sitting down on the ground, and the person alleged to be Mr. Al-Hassan is also sitting in the sand. And that is all we see for 5 seconds. He doesn't walk or talk to anyone. He just sits in the sand. This is not a security pose. It's the pose of an irrelevant bystander, someone whose presence had no measurable impact on the actions that took place. The third video is a French 2 documentary, Sur la haine des islamistes. And you have heard evidence that this documentary was edited to demonize the Islamists. And my colleague Maître Pradin will elaborate on this. But Your Honours, this is a court. It shouldn't rely on fake news. But yesterday, that's what the prosecution tried to feed you. First, they took a screenshot of Al-Hassan with his hand up, and they claimed that he was hiding his face. But if you watch the video at the 2-minute .50 mark, you will see he's not hiding his face. He's actually waving in a friendly manner at a journalist. But of greater concern, they played the soundtrack from the documentary where you hear a French female voice saying, "Arrête, arrête." And they claimed that this is what Al-Hassan heard. The soundtrack, the sounds of this French female voice, these were fabricated and laid over the footage without any consultation with the person who shot the film. And what is worse is that the prosecution knew the soundtrack is flawed. And they know that because we told them time and again in our objections. And you can see this, Your Honours, explained and written in full in filing 1808 at footnote 61. Mr. President, Your Honours, please don't let this fabricated soundtrack cloud your judgment. When you heard the source footage played in court with P150, what you heard was Radwan's voice, a male voice, and he was saying, "It's finished, it's finished." It was transcript 98 at page 54. And when you look at the footage without the fabricated overlay, you will see that the person alleged to be Al-Hassan is simply standing in the background, not interacting with the persons who are conducting the flogging. He's not facing the local population, and again, his presence had no impact on security. At 5.53 of the documentary, the flogging ends. The locals all walk wherever they want. Some towards the Islamists, some in the other direction, and there was no security barricade directing or controlling them. None of these videos show the person alleged to be Hassan making a meaningful contribution to the flogging that took place. The chamber heard evidence that Talha and his security officers were in charge of security that day. The chamber also heard evidence that the head of Hezbollah was in charge of overseeing the floggings, ensuring they complied with Islamic law. The highest member of the Timbuktu High Islamic Council, Grand Imam Sayuti, attended the flogging, sitting next to Hooka Hooka. As P150 testified, the locals freely attended as if they were in agreement. In this backdrop, Mr. Hassan is at most a fly on the wall. The flogging would have taken place in exactly the same manner if he was there or not. There's no basis to conclude beyond reasonable doubt that he made a meaningful and measurable contribution to the incident. The presence and oversight conducted by Hezbollah does, however, create a reasonable foundation for someone in his shoes to believe that the punishment was properly decided and issued in accordance with Islamic law. I'm moving on to late June, and we have explained in our response why the claim that Hassan drove an unarmoured car through a metal gate to check for mines is completely implausible and controverted by the body of evidence before you. The claim is not probative of guilt. It's just an example of throwing lots of random claims at the wall and hoping something sticks. So this brings us to July. And it's important to pause and focus on context. After the MLA left the airport, many former members of the MLA joined Ansar Dine, and you heard evidence they did so because there was no other choice for Tuaregs in or around Timbuktu. In July, Hassan's wife would have given birth to their daughter Layla, making it practically impossible to traverse the dangerous route to Mauritania. Prosecution witness P582 gave evidence that demonstrates that once you started working with Ansar Dine, leaving the group was not an option. P582 had arrived in Timbuktu at this point and joined the Islamic police. When he asked to leave after a couple of weeks, he was advised that the Malian army would arrest him, a sure pathway to torture or death. When he asked a bit later if he could leave to collect his family, his request was denied and he was forced to do military training. The prospect of being tortured or killed by the Malian army, this wasn't hypothetical. This prospect existed from the beginning until the end of the charged offence. And throughout this trial, the prosecution heard multiple prosecution and defence witnesses describe what P65 termed the ethnic cleansing of Tuaregs. Even civilian Tuaregs who were fleeing Mali were targeted. P1086 described to you the torture of 2 Tuareg companions who were captured by pro-government militia while attempting to reach refugee camps. The chamber also heard evidence that even if Hassan managed to avoid the army, even if he managed to survive this dangerous route, he would not have been allowed access to the refugee camps as a former member of Ansar Dine. Fleeing Timbuktu with his newborn daughter was not an option at this point in time for Hassan. Prosecution has not shown that Al-Hassan freely contributed to the commission of crimes in this month. They have also not shown that his alleged involvement in what took place increased the level of harm for the local population. Yesterday, the prosecution once again showed a heavily edited and spliced video of a flogging of 2 males. And they have asked you to reach conclusions based on speculation. Now, you've heard evidence from P65 that what you see in these videos is a puzzle where all the pieces have been rearranged. And you don't have the original unedited footage to see what has changed and what is missing. And after almost 10 years of investigations, the prosecution has not brought you any untainted evidence that would allow you to reliably reconstruct these events. We don't have a report. We don't have a judgment. The prosecutor still hasn't ascertained the names of the people who were flogged. So there's no foundation to ascertain whether they were civilians or Islamists or persons who accepted the Sharia. And when describing this flogging in his notebook, P4 seemed to characterize the event as having been purposefully constructed. He wrote that Al Jazeera journalists were in town and were there to fix activities and show that Sharia was in application. P4 further wrote that the Islamists gave the 2 flogged individuals a significant sum of 50,000 CFA. And that's at page 0678 of the transcript of his notebook. Now, rather than conducting an independent and impartial investigation into this incident, the prosecution has instead based their case entirely on broken up footage and broken memories from a broken man. And I'm speaking here about their continued reliance on the interviews they conducted with Mr. Al-Hassan while he was held at the Securitate in Bamako. The prosecution investigators asked him about this incident on 2nd of October. It was a 2-day session. At the start of these sessions, he told the prosecution he was still held incommunicado. He tells them he's still being interrogated by security services from the prison. He tells them he can be tortured at any time. Al-Hassan asks them, given that his psychological state doesn't allow him to function, given that he doesn't have rights, is it lawful to be interviewed like this? The prosecution investigators tell him it is, that the judges knew of the conditions and approved it. So moving forward to the day 2 of this session, 6th of October. It's the 4th session of that day, starting at 2 p.m. And at the end, he is so desperate that he begs the prosecution to intervene, to transfer him to a lawful prison, one under the Ministry of Justice, but they refuse. They tell him he has no right to even ask for such things. This is the interview session that the prosecution relies on. And when they do so, they pick and choose from these tainted transcripts while ignoring pertinent details. Specifically, in this interview, he tells the prosecution that the 2 individuals were convicted and sentenced by the tribunal for public drunkenness, that it was treated by the tribunal as a hudud punishment. There's no evidence that Al-Hassan played a role in the arrest or the proceedings of the tribunal itself. He also tells them that he was designated by the emir of the police, or Abu Dar, to execute the tribunal's order. And as Dr. Gary will elaborate, it was inconceivable for someone in Mr. Alassane position to refuse to execute such an order. And you saw at the scene of the punishment, Abu Dar is present, acting as a deputy for Adama. You heard evidence Abu Jabbar, a close associate of Abu Zaid, was present to enforce the punishment in accordance with the tribunal's order. If Alassane had not been in there, another person would have stepped in and taken his place. The individuals were also punished in a manner that conformed to Sharia, using a technique that was designed to avoid disproportionate pain or suffering. And there is no evidence regarding injuries sustained by the individuals. Given that corporal punishment for alcohol is practiced in several Islamic and non-Islamic jurisdictions, the superior order was not manifestly unlawful for someone from Mr. Alassane's milieu. Turning to the next cog in the prosecution's flawed plan. The prosecution relies on an encounter between P4 and Alassane at the BMS on 11th of July to describe Mr. Alassane as a deputy. The evidence concerning this encounter nonetheless shows that he was still functioning as an interpreter. And when testifying, P4 confirmed that Adam used Alassane as an interpreter, in particular relation to the French and Songhai languages, which is the language that P4 spoke. The core data records also show a pattern of conduct from this day, where you see an individual who is complaining about his car first call Adam. There's a brief contact, and then shortly after, the same individual calls the number attributed to Alassane. So this call pattern is consistent with someone who received, interpreted, or recorded information for the emir with different interlocutors who could not speak the same language. The interaction in question also concerned efforts by the police to identify the owner of the vehicle. And according to P4, once the police realized they'd made a mistake, the car was returned to the rightful owner with an apology and an offer to repair damage. The encounter thus shows that Alassane's day-to-day activities were directed towards assisting the local population. His presence, as someone who facilitated dialogue between members of the group and locals, made a positive contribution to civilian welfare. The prosecution have also attempted to boost Mr. Alassane's alleged seniority by claiming that the Emir of Timbuktu, Abu Zaid himself, was seen leaving Alassane's office at this time. First, this isn't what P4 actually wrote or said. He wrote that Abu Zaid left the office of the commissaire, and when he testified, he confirmed that it was Adam. Second, we don't know why Abu Zaid was there or what he was doing. He could have been paying a parking fine for all we know. The claim demonstrates nothing. I'm turning now to Mr. Alassane's alleged presence at a public punishment on 14th of July. The event concerned a member of the group punished for theft. It's not a charged incident. It doesn't concern crimes committed against civilians or the local population. His alleged presence does, however, provide a platform for you to make findings that he was acting under duress. You will also see from the video that he's in this scene an irrelevant little fish, someone following orders, not a decision maker. And you've heard evidence that this member of the group was convicted by the Islamic Tribunal. You've also heard evidence that the head of Hezbollah was present to oversee the correct application of Sharia. And in this blurry video, the person alleged to be Hassan is again standing in the background. He's not participating in the punishment, he's not supervising it, he's not ordering it. He's unarmed, and he can be seen clutching his boo-boo as if he were afraid. And it's reasonable to infer he was afraid. P582 gave evidence that when members of the group were punished, the police were made to watch, to give the police a lesson. This video doesn't show that Hassan had the power or the position to make culpable contributions, but it does, however, show that he knew he would be punished severely if he failed to follow superior orders. I'm moving now to the report of 16th of July, and this refers to an individual who was found in the act of selling contraband. Now, after 8 years of investigation, 3 years of trial, this is what the prosecution has not established. First, they have not adduced any evidence as concerns who arrested this person. There is, moreover, no proven link between this arrest and Mr. Hassan. Second, apart from the tainted interviews with Hassan, the prosecution has not adduced any evidence as concerns who conducted the interrogations of this individual. The report itself does not state that the individuals were arrested, interrogated, or tortured by members of the Islamic police. There's also no indication that the report was written at the same time of the interrogation, and indeed, given its short, summary nature and the fact it doesn't contain any quotes or details, the reasonable inference is that it was prepared afterwards and not in tandem with the interrogation. There is, moreover, no factual allegation or description of what was done to the person when he was interrogated. This makes it impossible for you to conclude whether the way he was interrogated actually fulfills the criteria for torture. There is simply insufficient detail to make reliable findings of fact concerning the link between this interrogation and Mr. Hassan's personal responsibility. This missing link also can't be found in Mr. Hassan's statements. And he was questioned about this report when he was clearly exhibiting signs of psychological distress and impairment. His evidence also does not show any blameworthy participation on his part. The prosecution investigators questioned Mr. Hassan about this report on 8th of December and 16th of January, and I'll deal with each interview in turn, starting with 8th of December. At this point in time, Your Honours, Mr. Hassan had been incommunicado for 8 months. He was in cell 6, a cell shared with around 20 people. The chamber has heard evidence that the floors, tiles in the cell were about 1/3 of a metre, and each person had about a tile and a half for space. Desperate, the detainees staged a protest, tapping on their doors to ask for better conditions, and the guards responded brutally. The chamber heard evidence that each detainee was taken out, including Hassan. Hassan was then forced to lie on his stomach while the guards beat him with whips and sticks. A witness saw blue bruises on Hassan's body afterwards, particularly on his buttocks. The already meagre food rations were then reduced to a third for 3 days, and the guards refused to empty the toilet pots for 3 days. Imagine this beaten, bruised man crammed into a space that was about the size of an A3 piece of paper. This size, starving, overwhelmed with the stench of urine and feces. These were Hassan's experiences and conditions in the lead up to his December interview with the prosecution. And when Mr. Hassan's lawyer raised what happened to him with the prosecution, they claimed it wasn't relevant. So Hassan's lawyer gave him a paracetamol, and the interviews continued. The investigator gave Hassan the 16th of July report and asked him to read it, questioning him repeatedly, trying to pin him down. During the interview, Hassan tells the investigator he doesn't know how the suspect was interrogated. He tells them that the interrogation did not take place in the police station, and he doesn't know where it took place. He also expresses his belief that the suspect was only condemned to 2 months in prison and then released. That is, that he was never flogged. The prosecution then interrogated him again on 16th of January. The interview starts. Hassan says, "I have a small ask, petty demand." He tells the prosecution he's fallen ill. He's suffering from psychological exhaustion, described by the interpreter as depression. He has enormous pain in his head. He has fever and pain in his teeth. He's received no medication. And at this point, he's still incommunicado. He's still in cell 6, where he was a human sardine in a tin. There are clear indicia that he was not physically or psychologically fit to be questioned. But the two investigators, who have no medical background, took no steps to test his competence or cure his ailments. Instead, they promise him, after they finish the interview, they will speak to the Malian prosecutor, and they offer to take pauses in the meantime. Faced with this promise of help, a quasi-lifeline dangled in his face, Hassan agrees to continue the interview. Let's look at what he said. He states that this type of interrogation was not within his functions. It was only something he'd heard about. Therefore, it wasn't something he had seen or been present for. When the prosecution asks follow-up questions, he repeatedly states he does not know how such interrogations unfolded. He also tells the prosecution that such interrogation could only be ordered by the Islamic Tribunal. And Mr. President, Your Honours, this is consistent with a prosecution witness who testified that if such an interrogation took place, it would have been authorised by the tribunal in accordance with Sharia principles. That was transcript 95, page 140. Hassan also tells the prosecution that if someone had been tortured or threatened with torture and they didn't confess, then based on his understanding, the tribunal would free them. Now, this is what the chamber can reasonably conclude from what Hassan said. First, Hassan was not present and did not participate in interrogations involving torture. Second, it was his reasonable understanding that a person who had been tortured without confessing would be released by the tribunal. That is, at the time that the report was written, Hassan had no knowledge or awareness that the person would be subjected to future treatment amounting to a crime. Third, Hassan believed that after 2 weeks in detention, the person was released. This shows that Hassan had no knowledge and no involvement in the alleged flogging of this person, which has not been proven to have taken place. Now, this is what the Chamber cannot conclude on the basis of what Hassan said to the investigators. Even if you disbelieve Hassan's account that he was not involved in the interrogation, you have not received any evidence from any witness with personal knowledge of this interrogation. You either have Hassan's account or you have nothing. And you can't go from disbelief of one proposition to belief of a different, evidentially unsubstantiated proposition. That's not how the burden of proof works. I would like to refer the Chamber to the legal authority set out at footnote 245 of our confirmation submissions. That's filing number 394. I refer in particular to the ICTY No Below Appeals Judgment, paragraph 47. Ultimately, the police had no power not to write a report. After all, this was a case concerning a serious ado defence. The report would have been written and transmitted to the tribunal whether Mr. Hassan was there or not. The fact that the report expressly recorded mistreatment of the suspect did, however, make it more likely the suspect would receive lenience. It made it more likely that he would be released. So if anything, Hassan's alleged involvement in relation to actions that occurred independently of him diminished rather than increased the harm experienced by the suspect. Moving on to August. The prosecution closing brief simply claims for the month of August that Hassan continued his activities, and they refer to one theft report he allegedly signed. This report concerns the arrest of an individual who was deliberately sabotaging the electricity and water supply in Kibara, that is, around the airport. The individuals were causing severe harm to the local population. There's no indication who they were or who arrested them. The report describes the theft as relating to public property. The HUD penalty does not apply to such acts. There's no evidence concerning the judgment that was issued. Mr. Hassan's alleged act in drafting or signing this report is not probative of intentional involvement or contribution to the commission of charged crimes. In later sections of their brief, the prosecution also relies on a police report, or what they describe as a police report, concerning Halima Samek, and it's dated 28th of August. There is, Your Honour, no evidence that this document is in fact a police report. And when you draft your judgment, it's important to look at the original language version, because you will see that on this document there's no stamp and no signature on the document. When shown this document and asked about the handwriting, P150 stated that he did not recognise it. It's transcript 98, page 21. The related judgment also does not mention the police. To the contrary, it states that the case was brought by Abdallah Kaab to the tribunal. And this, Your Honours, is consistent with evidence that locals could bring complaints directly to the tribunal. And Metro Yusuf will address this as well. So there's no link between this incident and the police. There's absolutely no link with Mr. Hassan. There is, therefore, no basis for a conviction. Turning to September. The prosecution starts the month of September by relying on crisis committee notes written by one person who did not testify in relation to a meeting conducted by another person who did not testify. The precise contents of the meeting, the degree of specificity of the matters raised during the meeting are unknown. The identity of the agents discussed during the meeting is unknown. And although the notes are dated 9th of September, we actually have no idea when the meeting took place. This remote, second-hand hearsay does not form a reliable basis to reach findings of fact concerning Hassan's knowledge or his alleged contribution to charged acts of mistreatment. Even if the Chamber were to assume that Mr. Hassan was at this meeting, and even if we were to assume that the locals had correctly identified the agents as police officers and not members of Hezbollah, this note, this remote second-hand hearsay does not prove that Hassan played any role in their alleged misconduct, nor does it prove that he had knowledge of future acts of misconduct. The Chamber has received evidence that Mr. Hassan was with his family in Zoho from 14th to the 20th of August. This includes the 27th day of Ramadan, and this is a date which, according to the prosecution, locals complained that members of the group acted improperly. So Hassan was not in Timbuktu at the time. The Chamber has also heard evidence that the Emir, Abu Zaid and Sander, received these complaints. The Emir apologized, he provided compensation, and he issued specific directives to the police and the Hezbollah to ensure the proper treatment and protection of the local population. The offending officers were also disciplined. So the prosecution has not demonstrated that Hassan participated in or contributed to the alleged events on 27th day of Ramadan. And afterwards, given that the leaders responded positively to complaints, given that the offending agents were disciplined, there is no foundation to conclude that Hassan knew that it was virtually certain that police officers would commit exactions against locals in the future. And there is, Mr. President, Your Honours, no evidence that members of the Islamic police, as compared to Hezbollah, did commit abuses after this point. Once again, the link is missing, and there is no basis for a conviction. Moving on. Prosecution refers to Mr. Hassan's alleged actions in signing a convocation, asking someone to come to the Islamic police. This convocation is not related to a charged incident, but it does, however, demonstrate that individuals and witnesses were requested to come to the police by a slip of paper, not by force. And Metro Yusuf will elaborate further on this point. So I'm turning now to the elephant in the room. September was the month where the only amputation took place. That is the amputation of Dedi Omaiga. The prosecution's claim that Hassan was involved in the first arrest of Dedi Omaiga is founded entirely on torture-tainted evidence. Their characterization of this torture-tainted evidence is wrong, and there is, moreover, no culpable link between this first arrest and the ultimate outcome. So let's look at these torture-tainted interviews. Mr. Hassan was questioned about this incident on 11th of September 2017. At this point, he'd been held incommunicado for 4.5 months. And just a reminder, under human rights law, anything longer than 10 days is considered akin to psychological torture. When he met the prosecution on 6th of September, they asked him how he was, and he told them his situation had not changed. He had no rights. He had no right to contact his family, to receive information from the outside world, even to see the sun. None of those rights existed for him. On 11th of September, he was in a cell with 12 persons, in cell 2. This was the same cell in which a detainee called Saeed had died. Saeed had arrived in good health, but a few days later, after being beaten by guards, he died. This death happened just before Hassan was brought into cell 2. And the chamber has received evidence that when detainees arrived at the security detail, they were told about other detainees who had died from torture. P582 told the prosecution that the security detail was a cemetery, a place where you died or became crazy. Hassan was literally held in a graveyard at the point where he gave the only evidence relied upon by the prosecution to establish his involvement in the charges related to Dedi Omaiga. And my colleague Metro Pradhan will explain why the chamber can't rely on this evidence. But even if you were to examine it, you will see that it does not create a culpable link. The case was not initiated by the police, nor did Hassan play an intentional role in its denouement. As he explained to the investigators on the day in question, Adam passed by Mr. Hassan's to take him to work. They then came across a group of locals who complained that a house had been robbed. The locals themselves were trying to catch the thief. And the thief was easily found because he had stolen bags of rice from his neighbor and left a trail of rice behind him before going to sleep. When Hassan accepted Adam's offer of a lift to work, there is no way he could have known that it was a virtually certain occurrence that it would result in Dedi's arrest or his amputation. The chain of events was initiated by the local population. He was present by happenstance, and the prosecution has not established that his presence made the arrest more likely. Given the persistence of the locals, Dedi Omaiga would have been found and arrested whether Hassan was there or not. At this point in time, there had been 7 judgments for theft issued by the Islamic Tribunal, and none of them had resulted in amputation or serious punishment. Hassan's not a religious scholar, and there's no evidence that he knew that it was a virtually certain consequence the tribunal would issue a completely different punishment than had done so on all prior 7 occasions. There was also a rupture in the chain of causation between the civilian-initiated arrest and the ultimate punishment. This rupture, this intervening act, relates to Dedi's escape from prison with the rapist Bokar. And you've heard evidence that the local population was up in arms about Bokar's arrest or escape. A local journalist even complained that it wasn't the first time that prisoners had escaped from the Islamists. Following pressure from locals, the leaders posted a reward for the arrest of Bokar, the rapist. It turns out that Dedi Omaiga continued to associate with this wanted rapist and was then caught by a local. The local population then arranged for him to be rearrested. You have this evidence. Mr. Hassan's alleged presence during the first arrest had no impact on the circumstances of his capture and no impact on his second arrest. There's not even any evidence that Hassan was working or present in Timbuktu when the second arrest occurred. And according to the court data records, he was in Zoho between 9th and 10th of September, returning on the 10th. There's also no evidence that Hassan contributed to the proceedings before the tribunal in any shape or form. There's in fact no police report concerning this case. The judgment states the defendant confessed before the tribunal. It also states that the tribunal conducted its own inquiry into the circumstances. The judgment makes no reference to the police or a police report. The subsequent punishment also has no proven link to Mr. Hassan. He was not present, and the prosecution has not proved that he played any role in its organisation or execution. Now, the prosecution's closing brief claims that Adam and members of the police were present, but this claim is not correct or reliable. First, Adam wasn't even a member of the police at this point. Second, the reference to other police being present is based on the testimony of P654, who only identified one individual in a video. The presence of one alleged police officer in a scene of over 24 persons constitutes a negligible presence, with no proven personal link to Mr. Hassan. There are also reasonable grounds to conclude that P654 was mistaken as concerns what he saw. This video forms part of a series of videos apparently shot on the same day. I refer you to transcript 128, page 85. Now, when a video from this series was shown to prosecution witness P150, he claimed to recognize himself in the video. P150 also testified that these images were filmed on the day of Musa's execution, not the amputation. That's transcript 89, page 128. They can't both be right. Either P150 provided incorrect testimony when he claimed to be absent on the day of the amputation, or these scenes relate to a completely different, uncharged event. There were also no amputations after this case. Locals, as Ms. Metro Yusuf will explain, continued to bring theft cases to the police, and the police in turn were obliged to transmit them to the tribunal. But as we set out at paragraph 79 of our response, each subsequent police report set out grounds that allowed the tribunal to avoid opposing the amputation. And P582 explained to the prosecution this was not incidental. The police did not support this form of punishment and tried to frame information in a way that meant that the criteria for imposing an amputation were not met. P582 gave the example of someone who was accused of stealing a weapon. And since the theft of public property doesn't result in amputation, the police claimed the stolen weapon was theirs. And when this didn't work, Hassan suggested that they help the individual escape. Now, the prosecution has, of course, attempted to downplay Mr. Hassan's considerable efforts to help the population by claiming he only helped this individual because this individual was a member of the group. But this claim does not match reality or the evidence in the case. The Chamber has evidence from P582 that Hassan suggested that when P582 interpreted for locals, he should interpret in a way that helped or favoured the locals over the group. The Chamber also heard from D605 that Hassan helped locals to obtain reduced penalties, in particular in the case concerning someone who is technically a slave. D272 also explained the assistance Al-Hassan provided to a local member of the Kel and Okanda tribe. Mr. President, Your Honours, the evidence shows that Al-Hassan's presence, his involvement in the Islamic police in September, continued to make a positive contribution to civilian welfare and not a culpable contribution to crimes. For the month of October, the prosecution tries to rely on a video interview filmed at the Gouverneur to establish his alleged involvement in incidents. But if you watch the video in context, if you read the transcripts closely, the evidence will actually lead you to the opposite result. The video is one of a series of videos. And while the prosecution report from P75 states the video ending with 3710 was filmed on 5th of October, the report also states the linked videos ending with 3712, 3714 and 3716 were filmed on 6th October at around 10:59, 11:50 and 11:58. And since the person in the video is wearing the same clothes, there's a reasonable foundation to conclude that the videos were all filmed on 6th October. Now, this date is important for a number of reasons. In particular, I'll start first with a video that was filmed on the 5th of October. That's video ending with 3724. When you listen and watch this video, you will see the person, the filmmaker in question. He was camped outside the Gouverneur. He was trying to bag an interview, and he runs into Sander. They discuss the fact that they've drafted questions. The speakers mention the press office, and they also mention the word or name Ahmed. Now, the chamber has heard evidence that an individual called Ahmed, that is Ahmed Al-Faki, was supposed to be the key subject of a documentary focusing on the role of Hezbollah. And in the documentary proposal, Hezbollah was described erroneously as the Islamic police. The chamber has also heard evidence that because of a car accident, Ahmed, the star, was convalescing. And the media office had been asked to propose a local Tuareg substitute, one who could presumably speak Arabic, which was the language of the original interviews conducted with Ahmed Al-Faki. And then, hey voila, the person identified as Al-Hassan is trotted out to speak about issues that would normally be dealt with by the convalescing star, Ahmed. Turning to the videos themselves, let's look at the video ending with 3710. It's filmed in an office, and there's a desk with 2 chairs in front of the computer. 2 chairs, not 1 chair. So it's 2, one for the emir and one for the interpreter who assists him. If this was Al-Hassan's desk, as opposed to one that was being borrowed for a staged film, there would be no need for 2 chairs behind this desk. In this call, in this video, you hear the person receiving a call in Tamashek. And this was confirmed by P150 at transcript 94, page 7. But unfortunately, when the prosecutor prepared their transcripts, they left out these Tamashek components. But these components are elucidated in the linked video, ending with 3712. And specifically, you can hear that after receiving this call in Tamashek from locals in the first video, the person identified as Al-Hassan calls Khaled in Arabic, and he tells them what he has heard. That is, that locals have caught a thief in Bur and want to hand him over. So in these videos, he is relaying information he received from one language into another language. He's acting as the human equivalent of Google Translate. He then asks Khaled to come to the office, saying that it was important for Khaled to return immediately. He's then asked about the type of cases they're dealing with at this point, and he says, mostly social cases, mostly, for the most part. Disputes between neighbours and such. The type of disputes that were brought to them by the locals themselves. Critically, he states the police does not have the power to make decisions on such matters. He states that they were obliged to send them to the tribunal. And in the linked video, 3710, he further states that the group worked hand in hand with the local imams and local religious scholars, that there was a perfect cooperation between them. This view concerning the constructive synergy between Ansar Deen and local imams was shared by key notables. I refer to transcript 107, page 79, and also paragraph 113 of P114's first statement, where he gave evidence that according to the ulama of Timbuktu, they considered Abdallah al-Tingeti to be preaching in a non-violent, moderate manner. Your Honours, if you choose to rely on these videos, even though the person who filmed them did not testify, even though you don't have the full context, these are the reasonable conclusions you can draw. 1, theft cases were brought to the police by locals. And this shows that the local population supported the existence of the police and the existence of a system regulating law and order. 2, when these cases were brought to the police, Mr. Al-Hassan is unable to deal with the cases themselves. He's neither the emir in name nor in practice. And this conclusion is corroborated by P582, who gave evidence that Al-Hassan refused to take decisions whenever Khaled was absent. 3, it's reasonable to conclude that the majority of police work was social cases brought by the locals. And this shows that the local population supported the work of the police. Now, yesterday, the prosecution told you the rules were enforced through violence and threats. But here, you see the opposite. The locals freely chose to bring these cases to the police. The fact that the police were preoccupied with such social and civil cases, it also shows that there was no nexus between Mr. Al-Hassan's daily work and the alleged armed conflict. 4, the police did not have the power to make decisions or determinations on such matters. When locals freely brought them to the police acted as a letterbox. They received them and transmitted them to the tribunal, which did have the power. And 5, the person identified as Al-Hassan expresses the belief that the group was working collaboratively in perfect cooperation with local religious leaders and notables. So this shows that Al-Hassan did not intentionally contribute to a system he knew to be contrary to local values or local wishes. Mr. President, I'm looking at the time. Is this a
Tout à fait, Maître Taylor. Il est 13h01. Je pense qu'il est temps pour nous interrompre. Nous allons donc suspendre l'audience pour la pause déjeuner et nous reprendrons à 14h30 comme d'habitude. L'audience est suspendue.
All rise, we will event.